Thank you, Mr. Leader. Would the sponsor yield?
Mr. Weprin, will you yield?
Certainly.
Mr. Weprin yields, sir.
Mr. Weprin, is there any requirement under this bill that the birth parents receive actual notice?
Not to my knowledge, but hopefully, it's very likely that in some cases the birth parents are deceased.
Is there any obligation under this bill, absent of showing that the birth parents are deceased, that they receive actual notice?
Again, this is a compromise bill. As far as I'm concerned, my original bill allowed release of the adoptee's original birth certificate, which in my opinion is a piece of property that should belong to the adoptee when they reach 18 years of age.
I appreciate your objective and concern. My question was, is there anything in this bill that actually requires the birth parents, if they're alive, to receive actual notice?
No.
Is there any requirement under this bill that the notice procedures be consistent with the notice procedures that we require for a simple civil lawsuit? In other words, given to the sheriff for service, or given for personal service, or nail and mail, or any of those statutory provisions that we currently require for a simple civil lawsuit?
Well, Mr. Goodell, I look at this as a different situation because prior to 1935, no birth certificates in New York State.
Mr. Weprin, I apologize for interrupting. I understand you view this as differently. My question was, is there anything in this bill that requires the notice provisions to be consistent with what we require for a simple lawsuit under the CPLR?
Not to my knowledge.
This application, the earliest this application could be submitted is when an individual turns 18, correct?
That is correct.
Is there any statute of limitations? Do they have to submit the application, say, within the first 6 years after they turn 18? I mean, we typically have statute of limitations in other areas.
No, it's 18 or older.
Okay. So we turn to the health department and we say, you have 120 days to locate the parents and notify them, but we don't require them to do personal service. We know the information they're dealing with could be at least 18 years and might be 5 or 6 decades old, right?
That is correct.
Now, since 1935, we've been telling the parents that put up, the birth parents that put up a child for adoption, that their decision would be kept strictly confidential, correct?
That is not correct.
And what have we been telling people in terms of the confidentiality of their identity?
No one was ever promised confidentiality. As a matter of fact, when a birth parent relinquished a child, that very rarely occurs at adoption, or certainly did not occur at adoption. They relinquished that child, and that birth certificate was not sealed until that child was subsequently adopted. It could be a matter of days, it could be a matter of months, it could be a matter of years. So we've never found a document assuring a birth parent of anonymity. There is no such document. It does not exist. We had a hearing that lasted a full day at 250 Broadway, and not one individual, not one judge produced a physical document promising a birth parent anonymity because it doesn't exist.
But under current law, they're entitled to confidentiality with a few exceptions that were brought up by my colleague, Ms. Weinstein.
That is not
correct?
true.
Oh, so right now, birth parents, their confidentiality does not exist?
That is true.
And so right now, an adoptee can find out the name and address and the identity of their birth parents under current law?
They do it all the time through the internet, through private investigators. This legislation would allow them to get that physical copy of their original birth certificate, which a lot of adoptees feel is an important part of their DNA, of their heritage, of their persona.
So just so I'm clear, you're saying that we don't need this bill because you can get it freely now?
You don't get the birth certificate now.
So we were promising birth parents for the last 81 years that the birth certificate would be confidential. Is that correct, with a few exceptions that were outlined by my colleague?
No, we just know that we're telling the adoptees that they can't get the birth certificate because it's sealed.
I see. So they've been sealed for 81 years. Maybe it's just a language problem. So we've been sealing these birth certificates for the last 81 years. Am I correct?
That's correct.
And we've been telling adoptive parents that these birth certificates are going to be sealed. And we've been telling them that for 81 years, right?
Yes, but we've never told them that they have anonymity or that we won't disclose their name.
I understand. There's other ways to find it out. But we're changing the law that's been in existence for 81 years in the state, where we told the birth parents that if you give up your child, that birth certificate is going to be sealed. And based on that explanation, and other factors, no doubt, birth mothers have given up their child for adoption, correct?
I don't believe that's the case, Mr. Goodell. I believe birth mothers have given up their child for adoption for many, many reasons, but certainly not any promise of anonymity.
And during your hearings, how many birth mothers did you talk to?
We had testimony from quite a few birth mothers at the hearing.
Whose identity was still confidential?
Well, they've come forward now. You know, by the way, we had many.
Well, maybe I didn't phrase the question correctly, and I apologize.
Mr. Goodell, it would be better if you let him answer. He was in the midst of an answer. And
Well, then let me help out. I withdraw the last question.
he didn't,
so I can
Mr.
clarify.
Goodell.
I didn't answer.
He didn't ask for help.
You know, many of the birth
Mr. Speaker,
parents.
may I withdraw the last question?
Certainly, sir.
Thank you. So let me be more clear. Did you have any birth mothers at any of your hearings who wanted to remain confidential in terms of their adoptee testify?
No. We did have birth parents, though, that were seeking the original birth certificate themselves, but they also did not have access to that original birth certificate because it was sealed.
Now, this bill doesn't apply effective upon adoption, right? It applies retroactively to birth certificates back 81 years?
It allows adoptees, once they apply to the court, to get their birth certificate after 120 days and a search.
Okay. Mr. Weprin, thank you for clarifying on the bill.
On the bill, Mr. Goodell.
Giving up a child is undoubtedly one of the most difficult things a mother can do. You go through the entire pregnancy. You give birth to a child, and you give up that child for adoption. I can only imagine how difficult that is for a mother. And I am sure for many fathers, it is also extremely difficult. And so why do they do it? They do it because they're hoping for a better future for their child. And they're willing to put their child's welfare above their own personal selfish interests. And we as a society want to encourage that incredible perspective of putting the child's interest first. And that's why we've told these birth mothers and the fathers that if you go through this incredibly difficult and sometimes incredibly painful process, we'll seal the birth certificate. And we've provided an alternative process. So if you change your mind and you want to reach out, you can do that. And our current law allows them to do that. But believe me, you, having gone through that process, there's a lot of birth mothers that don't want to go through it again. There's a lot of birth mothers that have moved on, maybe remarried, or maybe they weren't married in the first place, but they've moved on with their life, and they have kids that don't know they have an adoptive son or daughter, and mom has never told them. And we as a society have said, you know, when you adopt a child, when you're an adoptive parent, God bless you. You're doing God's work, in my opinion. God bless you. You've adopted a child, and we want you to have that relationship, that parent-child relationship, without anybody else interfering with that relationship. So when you work with your child, your adoptive child, we want you to treat them just like your own flesh and blood. And we don't want somebody else in the shadows second-guessing you. For 81 years, we've been telling parents that your birth certificate would be confidential for all those public policy reasons. Now, as my colleague, Ms. Weinstein, noted, we have procedures in place. So if you change your mind and you want to be known to your adoptive child, you can do it. You can make your name available. We have that procedure in place. And we have a procedure in place. So if there's a medical reason why you need to know your biological parent, you can go to surrogate's court, and there's a procedure. And I was involved in one of those. And I got a call from the surrogate's court, and they said, there's a child that was adopted. He needs a transplant. Will you reach out to the natural kids and the natural parents and find out if they're willing to have their identity released? And I did, one-on-one, on a confidential basis. So we have the protections in place. So now, all those moms and dads that made their decision to put up their child for adoption, to put their child's best interest first and foremost, who, for whatever reason, have moved on with life, we now say, you cannot believe what the state of New York says. Because we may have told you that over and over and over and over again, but we're changing the rules, and we're changing it in the middle of the game, and we're pulling the rug out from underneath you. And so make sure you reach out to your new husband and let him know you've got some kids you never told him about. Get ready for that meeting with an adoptive child that you put up because you love that child so much that you put that child's interest first, and you can look forward to that meeting. This is serious, serious stuff that we're talking about. And I've been there, and I've gone through this process with an adoptive family, and let me tell you, it's serious, serious stuff. It's one thing for us to say the rules are going to change starting tomorrow, because then we can tell adoptive parents, no, there's a new process. And 18 years from now, they may try to get a hold of you. But to apply it retroactive is a disservice and a violation of their privacy. And how do we make sure their privacy rights are reflected? Well, 20, 30, 40 years after they gave birth, we ask the health department in 120 days to find them and notify them. We don't require personal service. We don't require certified mail. We don't require mail and nail or post and nail or anything else that we require for a simple lawsuit. We don't even require that on a monumental issue as important as this. We as a legislature can do better. We can do better. And we should. So when you're dealing with people's lives on an issue that's so incredibly personal, we need to make sure that we have the checks and balances in place so that the privacy of the women and the fathers who gave up their birth of a child is protected and respected. We can do better, and we should. And because I am confident that this body can do better, I look forward to better legislation and will not be supporting this legislation. Thank you.
Read the last section.
This act shall take effect April 15th, 2017.
Clerk will record the vote. Mr. Levine to explain his vote.
Mr. Speaker, this is certainly controversial, as are many of the issues that we grapple with on a daily basis. I had received quite a few emails opposing this particular bill because the people who wrote me thought it did not go far enough. Now, I look at this from the perspective of someone who is now a little bit older, but it seems as if the older I get, as I learn more little bits and pieces about my history, and especially my family's history, the better I am able to understand myself, and much better am I able to understand my family. I can't for the life of me imagine how challenging it must be for someone to have no key, no clue, no connection to whoever it was who was their biological parents. So we have heard people opposing this bill because they somehow believe that parents who gave children up were putting the child's interests first. For me, it's a very simple proposition. Let us, in fact, put the interests of the child first. And I think the interests of the child are paramount. And to suggest that we are changing the rules in the middle of the game, I think misses the point a bit, because this is anything but a game. There's no gamesmanship in this whatsoever. We have an evolving sense of what's appropriate. We have an evolving sense, and this evolves for the better in terms of human rights and human dignity. Interestingly enough, the word privacy is defined as the state or condition, oh, I'm sorry, my machine just went off, but the state or condition of not being bothered or perturbed. I'm voting for this because adopted children should not be perturbed. They should not be bothered. They should have the right to privacy. That means they should know from whom they came. I commend the sponsor for this bill.
Mr. Levine in the affirmative. Mr. Titone.
Thank you, Mr. Speaker. You know, I want to remind this body the last time we debated this that, you know, this whole privacy and secrecy surrounding adoption, you know, didn't come about until the Victorian times, and that's, you know, suddenly we thought it was an embarrassment for a woman to become pregnant and, you know, bear children. So we've held on to that Victorian culture of secrecy. It used to be very much out in the open, and it was no big deal, no embarrassment. And, you know, I take offense, you know, having family members, a sister who was adopted as well as other family members in my household that are adopted, that when I hear not only, you know, from both sides of the aisle, the argument, well, the mother had the child and then she moved on, so we have to go. Well, you know, that's fine and good, but here's the rub. The child never gets to move on, ever. And in my opinion, in my experience, that is unfair. And it's a kind of almost offensive to hear the argument, well, the mother's moved on, let it be. When children are suffering and they never, ever get to move on. So I think this is a good bill. I think it does strike the right balance. I commend the sponsor for it, and I would encourage my colleagues from both sides of the aisle to vote yes on it. I'll be voting yes, Mr. Speaker.
Mr. Titone in the affirmative. Mr. Butler.
Thank you very much, Mr. Speaker. I've listened to this debate very carefully, and as an adoptive parent, I wanted to add my perspective to perhaps give a little more clarification to this issue. I have a daughter who is now 30 years old, and her birth mother left her a letter and said that she would reunite with her when she turned 18 on the adoption registry. I took her to the registry, and the mother did not do that, and my daughter's attitude was that it was like her mother abandoned her twice. It caused her a great deal of anguish, a great deal of emotional damage, and I think that this bill, weighing the pros and cons, I think it's important for many adopted children. They want to know where they came from. They want to know about their background. And quite frankly, it's been pointed out, I think we live in an era where some of the old objections or perceptions about adoptive parents and children has changed. So I think this law reflects the new kind of thinking. I don't think parents are going to be discriminated against or whatever you might want to believe. And I really suspect that perhaps as time goes by, perhaps some of these mothers and fathers who gave up children to adoption may themselves be interested to see how things turned out for them. I wish my daughter and her birth mother could get back together. We still hold that hope out, but it's been a long while. But I will tell you, it was very damaging to my daughter to feel that she'd been abandoned. So with that, Mr. Speaker, I'm going to vote in the affirmative.
Mr. Butler in the affirmative. Mr. Barron.
Thank you, Mr. Speaker. This has been a very, very difficult decision. I heard passionate pleas on both sides, and both parties certainly have a right to things, certainly the parents and certainly the adoptee. But from all that I'm hearing, and I think with the sponsor bending a bit, changing a bit to allow for privacy within the 120 days, trying to notify the birth parent, even though some may not feel that the process is sufficient enough in that 120 days to locate the birth parent. I just can't even fathom how it might feel if I had no idea who my birth parents were. And I can't even fathom if I had no way of getting my original birth certificate. I think these things are very, very difficult for the adoptee to be able to go through life and not know this. But this is not an easy one, because I certainly can understand the other arguments and maybe a life that's going well for a family with the adoptee not knowing their original, their birth parents and not being able to get their birth certificate. It might provide for a smoother life for some families, or perhaps not for other families. But when all is said and done, I fall on the side of the adoptee. The adoptee should have the ability to get their birth certificate, and for the sponsor of the bill to say that, look, we'll try our best, or we'll make a good faith effort to get in touch with the birth parents so that they can take their names off and the birth certificate can be given to the adoptee without their names. I think that that is a measure. Maybe the efforts to get in touch was not enough, but because of that, I am going to vote yes on this piece of
Mr. Barron in the affirmative. Mr. O'Donnell.
The current law permits adoptees to get access to this information by going to surrogates court. Like one of the previous speakers, I assisted a constituent, actually a next-door neighbor of mine, who desperately wanted and needed that information, and it was granted in an almost cursory fashion. The suggestion here that we need to change these rules, I hear, and I've heard from some people, but I've also heard from adoptees themselves, some of whom actually oppose this bill. I am not an adoptee, although I have adopted family relations, and so I know how difficult this decision must be. But in the end, I don't think that this bill is necessary. I think the current law permits them to do that when they need to do that, and whether or not we accept it or believe it, or whether or not we think it should be that way now, there was a time when we gave assurances that that decision would not be reopened. I want to state clearly for the record that I support open adoption and would support a bill that going forward, all adoptions in New York have these rules, or all adoptions in New York at a certain time become open. But that's not what this bill does, and this bill is not necessary, and I will be voting in the negative. Thank you.
Thank you, Mr. O'Donnell in the negative. Mr. Gottfried.
Thank you, Mr. Speaker. To me, this issue is a question of human rights. The child was never asked what he or she thought about this whole matter. The child is now an adult. Many of them may not be interested in knowing who their birth parents were, but many of them deeply and profoundly want and need this information. It is about as personal information about a New Yorker as you can get. And to me, every New Yorker has a fundamental human right to know who they are. I share Mr. Weprin's wish that this bill was simpler and cleaner and went farther, but we don't always have that option. Sometimes we get as much as we can achieve and come back to seek more at a later day. I very much support this bill. It's a long time coming.
Mr. Gottfried in the affirmative. Are there any other votes? Announce the results.
Ayes 101, noes 24.
The bill is passed. Mr. Morelli.
Yes, sir. If we could go to page 22 of the main calendar and take up calendar number 239 by Ms. Glick.
Assembly 6221, calendar 239. Ms. Glick, an act to amend the public health law.
An explanation is requested. Ms. Glick.
Certainly, Mr. Speaker. The bill seeks to codify in state law the Supreme Court decision in Roe v. Wade. As many of you know, our state laws changed in 1970, which predated the Roe v. Wade decision. And so for years, there are aspects of the law where we have to rely on federal law rather than simply on state law, and this is to ensure that the women of New York State, regardless of what happens in Washington, will have the protections that they have enjoyed for the last 40-some-odd years. It is important, I think, to note that these are there's nothing in the bill that would obviate any of the religious exemptions that currently are enjoyed by either hospitals or individual practitioners who have the right to refuse, based on their religious beliefs, to participate in any abortion services. It simply says that women who, whether unintended or in some instances when birth control fails, which it does a fair amount of time, that they are not required to, to against their will, carry a child to term. So this bill is simply a codification of Roe v. Wade with, as I said, all of the religious exemption protections intact.
Mr. Walter,
Mr. Speaker, will the sponsor yield?
will you yield, Ms. Glick?
Of course.
Ms. Glick yields.
Thank you, Ms. Glick. In the first sentence, you referenced Roe v. Wade. You just mentioned that the intent is to codify the decision in Roe v. Wade. Do you know of any other references in our...
I'm sorry, I'm having trouble hearing the gentleman.
Certainly, maybe we need to shh a little bit.
He's so tall, he's not as close to the microphone as I am.
I wish I was a little taller. I'd be thinner. But the first sentence you referenced Roe v. Wade. So it's your intent to codify the decision in Roe v. Wade?
Yes.
Do you know of any other situation where we actually reference a Supreme Court decision in state law in order to set up a legal framework?
Not being an attorney who spent years in law school, I can't reference one in particular, but I'm simply saying that that's a shorthand way of explaining the bill.
Okay. It's a concern, obviously, because I couldn't find any when I looked. I did go to law school, but we didn't review all of New York State laws. Thank goodness. But it's a concern only because when the Supreme Court makes a decision, what they're doing is they're deciding whether or not an existing law is constitutional or not. And they're not really setting up a legal framework to operate a state by. I mean, is that a concern when you draft?
Well, I would actually disagree with you. I think that when the Supreme Court sets up a framework, it is indeed suggesting to all of the states that these are the parameters for what will pass constitutional muster. So I actually think that there are, otherwise there wouldn't be states that are constantly trying to find instances where they can challenge one or another aspect of any number of Supreme Court decisions, whether it has to do with other types of health care laws that we have had in the country. There have been many attempts to challenge various statutes, and we referenced the Supreme Court decision and framework that has set out the landscape upon which individual states can, in fact, enact laws that do not run afoul of the U.S. Constitution. So your premise is not one that I accept.
Well, no, I agree with exactly what you're saying. So I think we probably do agree. It does establish a framework, but it's up to us. It's up to us as the legislature to fill in the details in between that framework. So when Roe was decided, it didn't just decide that a woman had a right to an abortion. It also decided that the state had a legitimate interest in protecting the health of the mother and also what the court referred to as the potentiality of human life. So within that framework, with the first tier that they established was unfettered right within the first trimester. The second tier, in the second trimester, the state had an interest in protecting the woman's health. And then the third tier, the state then had a much more active interest in protecting the potentiality of human life, as they described it. We have laws on the books to protect the health of the mother within the framework of the Roe versus Wade decision already, don't we?
No.
We don't.
We protect a mother's life, not her health, and that's exactly the point.
Well, if we just did that, then we would be afoul of the Supreme Court decision, wouldn't we?
when individual cases should not have to be litigated in order to ensure that women have the right to have their health protected, which right now federally you would have to have in an instant you might in some instance have to go to federal court to ensure that your rights were protected. We shouldn't put anybody in that position. So this legislation would align state law with federal law. And we've done that in other instances, I'm certain.
Okay. Looking at the law itself and what you're proposing to do regarding the penal law, and I'm going to look at your bill here, it's page 2, line 8. So subdivisions 2 and 3 of section 125.05, subdivision 2 of section 125.15, on and on and on about the penal law. It says that, and this is the key here, the last sentence of these sections of the penal law are hereby repealed to the extent that they are inconsistent with this section, with the bill, without being part of Roe v. Wade.
Right.
So, looking at those parts of the penal law, maybe you can tell me which parts are repealed, which parts are inconsistent with those sections of your bill.
The penal law is criminal statutes, and so we have always felt that this matter should be in health law and not in penal law. So we don't believe that anybody should be prohibited if their scope of practice allows for them to perform an abortion.
I don't disagree. This probably should be in the health law. I agree with you 100% actually. But that's not what your bill says. We're amending the penal law. We're saying it's repealed to the extent it's inconsistent with this section. We're not adding a part of the health law or actually pointing out which sections are repealed or are inconsistent. So let's just take a section here. So let's say section 120.
Let me just say one thing, that former iterations of this bill did line out each specific thing. This bill is actually the Governor Cuomo's bill that was part of the Women's Equality Act, and it is the 10th point, which we have not, we've passed in this House, but not in the other House. And frankly, the rather lengthy version that existed in the past under a prior governor, I think would have done precisely what you're suggesting, which I was very comfortable with. This was this governor's attempt to streamline what was a much more lengthy measure.
Well, we see where the governor's attempts to streamline things have gotten them recently. So maybe we should go back to that, though. Section 125.05, Abortional Act, it talks about justifiable abortional act. So it says, an abortional act is justifiable when committed upon a female with her consent by a duly licensed physician, and then it goes on, acting A, under reasonable belief that such is necessary to preserve her life, or within 24 weeks from the commencement of her pregnancy. Is that inconsistent with your bill? Is it repealed? How would you say that falls in line with your bill? Is it repealed or inconsistent?
Could you reframe that or repeat that a little more clearly?
Sure.
Because there seemed to be a double negative, and I'm always nervous about responding to a double negative.
All right. Section
The
120.
English major in you.
Well, there you go. Let's see. I was only a history major, so. The abortional act is justifiable when committed upon a female with her consent by a duly licensed physician acting under a reasonable belief that such is necessary to preserve her life or within 24 weeks from the commencement of her pregnancy. Is that part repealed?
No.
No. So that is consistent with with Roe v. Wade, with your bill.
Yes, it is consistent with Roe v. Wade, except that there is no health exception provided. So it stops short of the full protections of Roe.